Hey attorney, I don't need a will or a trust or anything, right? Because I put my daughter on my house as a joint tenant, so that should take care of everything, right? Well, that is a very common thought. However, that is definitely not the best plan. Do you know what joint tenancy actually means? Yeah, it means she gets the house when I die. Simple and easy. Won't even have to go to probate court. Hmm. Well, it sounds simple, but it's actually not that simple, and it can get pretty messy. Here's the thing. What if your daughter has creditors? What if your daughter rear ends somebody and gets sued by the insurance company? What if your daughter goes through a divorce while you're still alive? Her creditors become your creditors, and you could lose your house due to her actions. Wait, so her problems become my problems? Exactly. And here's the other thing. Joint tenancy bypasses your will. So if you wanted your other kids to get a share of the house and it says that in your will, that won't happen because the joint tenancy means that the daughter who's on the house will receive it all and will have no obligation to give it to anybody else, despite what the will says. Oh no, I just wanted to avoid probate court. I didn't want to cause a family fight. What's a better plan? There are way better ways to avoid probate court and to protect your assets. A living trust, for example, is a much better approach to ensure that your wishes get followed without the risks associated with joint tenancy. Estate planning is much more than just avoiding probate court. It's also about protecting your family. If you want to make sure that your family is protected and that your assets are protected from having to go through probate court, follow more for more estate planning tips.